Hi everyone, and thanks for watching, and thanks for reading the drafts. We'd hoped to be doing this in person at the annual meeting, of course, and we're sorry that we won't be, but we will be seeing you later in person, and for now we hope that you'll submit comments through the ALI website or by sending an email to the project comments address. We will review and think about all of those. This video is of course not a substitute for the full presentation and discussion, but we're going to go over some of the draft. So to start with, I wanted to say a little bit about the overall goals of the project, since we haven't been to the membership yet. And I would say we've got three overall goals. So first, the second restatement was notoriously opaque and hard to use. It's hard as an open-ended 7-factor test, which tells courts to figure out which state has the most significant relationship to an issue in a case. And we want to give courts more guidance. So where case law applying the second restatement and other modern approaches supports it, we offer a rule. We tell courts which state's law to use. Second, we want to be clearer about the conceptual framework we're using. And we want that framework to resemble ordinary legal analysis as much as possible. We don't want to present choice of law as a strange, esoteric realm where none of the ordinary rules apply. So we have some sections, and they're in Chapter 5, not the draft that we're discussing today. But we have some sections describing how we think about the choice of law problem. That is, we have a little restatement of modern choice of law methodology. That's drawn from the second restatement and other modern approaches, but it's explained a little bit more. And what we say is choice of law is a process of figuring out which laws give the parties rights, and then, if necessary, resolving conflicts between those rights. And this is something that we do in the ordinary legal context, if we've got a statute in the common law, or federal law and state law. So it's not some mysterious sui generis process. And then third, we want to give users of the third restatement better guidance than the second restatement did, not just as to what the answer is, but as to how to use the restatement and what the rules are designed to achieve and why. So at various points, and again, not in the sections that we're discussing now, but later, we make an effort to tell judges or lawyers how they're supposed to use the rules we set out. And this is connected to the second goal, because having a conceptual framework lets us explain how the rules were created and what they're supposed to be doing. And to the extent that that conceptual framework resembles ordinary legal analysis, we hope this will be less forbiddingly strange to generalist lawyers and judges. So now I'm going to talk a little bit about the introductory sections. We start by defining states and nations, which are the entities whose laws might be selected through the choice of law process. Then we describe what the field of conflict of laws covers, and that's basically the jurisdiction of courts, choice of law, and recognition of judgments. The next section explains the difference between a state's internal law and its choice of law rules, which is a distinction that we need to draw at various points. We frequently tell courts to use other states' internal law, but we generally tell them to ignore the other state's choice of law rules. And the most interesting thing about this section is what to do with specifications of scope. So what if a state law says there's a cause of action for deaths caused in this state, or there's a right available to residents of this state? Now, this is an example of where we think a better developed conceptual framework helps. The second restatement is not clear on how it treats specifications of scope because it doesn't really explain what's going on in the choice of law process. To the extent that courts have confronted the issue explicitly, they say the second restatement treats these specifications as part of the internal law. And that is also what we do. But in the second restatement, it's murky, and we try to improve on that. We define internal law to include specifications of the geographic or personal scope of the law for three reasons. The first is conceptual. We're describing the first step of choice of law as the process of ascertaining the rights that parties have under different states' laws. And that's a matter of determining the content of those laws, which parties and which sets of facts they reach. Now, if a state tells you who can assert rights and under what circumstances, that's part of the content and meaning of its law. States have the ability to do that, so other states can't ignore what they say, as they typically would with a choice of law rule. And this is part of our project of trying to make choice of law cohere with ordinary legal analysis. Because of course, in the ordinary legal context, states do have authority over the scope and content of their law. The second reason is practical. If we put specifications of scope in the choice of law category, we would be telling courts to ignore scope specifications in sister state law. And the consequence of that would be disuniformity, which is generally undesirable in choice of law, and maybe especially undesirable when we're dealing with contractual choice of law clauses. And then the third reason, but not the least important, is to capture the practice of courts, which do give effect to sister state specifications of scope and as we've said, describe this as consistent with the second restatement. Then the last section of the introduction, we note that the international context may differ from the interstate one. And one of the things that we've tried to think about consistently is the application of the third restatement to the international context, because the second restatement was pretty domestic in its orientation. So in each section, we've tried to think about that, and sometimes we discuss it explicitly, but we also have this general acknowledgement and discussion. Now I'm going to turn it over to Laura Little to talk about domicile.
Hi there. The topic of conflict of laws is, I think, notoriously tricky. And one of the reasons it has that reputation is that it's very abstract. Well, the three of us as reporters wouldn't be here unless we actually embraced that abstract context and quality of conflict of laws. What makes it tricky for us is that it's transubstantive. It goes from common law subjects such as contracts, torts, property, into statutory informed concepts such as corporations, as well as United States constitutional issues. What this means for us is that we're enormously grateful for the expertise of our advisors in fact, informing these specific substantive concepts. And we look to you as the membership for further guidance. In terms of how we started with this project, we had a little bit of a chicken and the egg problem. That is, do we start with the general or do we go with the specific? One thing that occurred to all of us is that the concept of domicile, or the connection, the geographical connection between a person and a location, is something that actually goes through all of conflicts of laws. So we thought that made sense to start with. One of the as Kim Roosevelt suggested, one of the overriding sort of purposes or goals of this project is, number one, to try to give very, very clear guidance and specificity, unlike the restatement second. But at the same time, try to modernize to the extent that's consistent with the charge of the American Law Institute, to try to modernize some of the difficulties with what state courts were doing with conflict of laws under the second restatement. One of the problems that we identified with domicile as it was applied by the second restatement is that, in fact, it was adhering to basically the traditional approach of the first restatement. What is domicile? It's an intent to make a place your home, plus physical presence in a particular place. Well, the case law reflects that, in fact, there was a lot of tomfoolery when it comes to manipulating personal intent to make a place one's home, whether it be for the purpose of voting, whether it be for the purpose of inheritance taxes or whatever. There was a lot of action that was insincere, that was dogging the courts in terms of what did this person really intend. So one of the big changes that, in fact, we made, which was reflected in the case law, is to, in fact, make intent something that must be proven by objective evidence. Where are you religiously located? Where are you civically located? Where is your family located? Where is your work located? And the like. That is objective evidence of, in fact, where you intend to make a place your home. Now, you notice I'm talking in terms of you as a natural person. Another decision that we made in terms of this umbrella term domicile was to include what we call juridical persons, artificial persons, corporations, partnerships, and the like, under the umbrella of the term domicile. And I can tell you that we actually evaluated different ideas for what to call this geographical link. And we thought about, consistent with our notion of trying to be international in our vision, we thought about habitual residence, we thought about other ideas, but we ultimately settled on the word domicile. Now, Traditionally, domicile is not associated with corporations and other artificial persons, what we call juridical persons. But we decided for the purposes of people researching the third restatement and sort of referring back to what they know, that we would include those entities under the umbrella of domicile. So that was another big decision that we made. In terms of natural persons, we sort of track some of the typical questions that come up in terms of the domicile of minors, how do you deal with joint custody, what is domicile of origin, but we also try to accommodate sort of differences and transitions in modern life that weren't part of the reality of the second restatement, such as what about people that in fact very much split their life between one jurisdiction and another jurisdiction? What about individuals that live a long time, they suffer from dementia, they suffer from Alzheimer's and the like, that in fact change their physical location in order to be near their family, but may not be able to in fact manifest any even objective evidence of intent. So it's a way that in fact we try to modify the traditional rules in light of modern society. In terms of corporations and other juridical persons, we settled consistently on what Kim Roosevelt suggested was trying to have clear rules, a presumption. And the presumption is that in fact the domicile of a juridical person is the principal place of business. If the particular choice of law issue that arises suggests that another place is actually the more central geographic link for the corporation, partnership, and the like, then we have that flexibility. But we're trying to provide enough certainty so that planning and predictability are served by this particular document. Finally, I'd like to return to where I started. That is that this is in fact a diverse discipline. It covers many different topics, and that's where you come in. That is, we very much appreciate you listening to this video. We very much appreciate you looking at the draft, and hope that in fact we'll have your input in trying to evaluate whether or not in fact there might be tweaks that we can make in the draft. You can have critiques, you can celebrate how far you can celebrate the accomplishment, but we'd love to hear from you in your comments. Thank you. And now I'm going to pass it on to another reporter, Chris Whytock, who will talk to you about foreign law.
Thank you, Laura. And I'd like to join Laura in thanking all of you for watching this video and for any comments you might submit and for reading our draft. So Chapter 5, Topic 2 is the topic that I'll discuss, and that topic addresses the determination of foreign law. And as many of you, of course, know, a premise of choice of law is that a court in a given state or country does not necessarily apply its own domestic law. To the contrary, when conduct or injuries or parties to a dispute have connections to another state or country, the forum court may apply the other state's or country's law. That is, it may apply foreign law. The question is, how does a court determine the content and meaning of foreign law, which will almost certainly be less familiar to the court than domestic law? In the federal courts, there's some guidance in Rule 44.1 of the Federal Rules of Civil Procedure, along with case law interpreting that rule. But the states have many different types of rules governing the determination of foreign law, many modeled on Rule 44.1, but some states take a variety of different approaches. Moreover, both the federal and state rules leave a number of questions unanswered, which have been left to the courts. For its part, the second restatement of conflict of laws did not include much guidance on the determination of foreign law. Its black letter rules on this point only had a choice of law rule that said that the law of the forum governs the determination of foreign law, but its black letter did not provide guidance on how a court should determine foreign law. So based on an analysis of case law and due consideration of state and federal rules, this topic aims to restate the law governing the determination of the content and meaning of foreign law in a way that provides substantially more guidance than the second restatement. One clarification, this topic does not at all address whether in a given case foreign law applies. That question is covered based on the conceptual framework that Kim laid out at the beginning of our discussion, and that's implemented in chapters 6 and beyond of the restatement. But if under those rules foreign law applies, this topic provides for 3 distinct steps. First, if you read the draft, you'll see that under section 5.6, a party or the court gives notice of the application of foreign law or the potential application of foreign law. So notice is the first fundamental. To make sure that the court and the parties have a fair opportunity to respond to the assertion that foreign law applies and to have the time to make its own arguments about the meaning of foreign law. Second, under section 5.7, the parties and or the court obtain and share information about foreign law. And one point on which this restatement is emphatic, and it's consistent with Rule 44.1, is that even though the parties have the primary responsibility for doing research and providing information about foreign law, it's often appropriate for a court to do its own research about foreign law, just as it does research on any other kind of legal issue. And then third, under section 5.8, the next step is for the court to determine the content and meaning of foreign law based on the information obtained in the second step. To the extent possible, this topic's rules and comments are designed with several principles in mind. And the first is the overarching principle that was articulated in Rule 44.1 of the federal rules and is reflected in the case law of most states, is that the determination of foreign law is an issue of law, not fact. So when we talk about determining foreign law, we use the term determining foreign law or determining the content and meaning of foreign law, and we avoid the language of proof, which is language that has traditionally been used regarding issues of foreign law, but is increasingly rejected in favor of the idea of determination of foreign law, since it's an issue of law, not fact. Second, the best practice is for the parties and the court to cooperate with the goal of identifying and resolving issues of foreign law early in the proceedings. Third, the rules governing the determination of foreign law should facilitate and encourage the correct determination of foreign law. And then fourth, the rules should facilitate the efficient determination of foreign law, taking into account both the importance of foreign law in particular cases and the resources available to the court and to the parties. Like the law of most states, this topic provides guidance for the determination of the law of a foreign US state and also for the determination of the law of a foreign country. Nevertheless, even though this topic covers both sister state law and the law of a foreign country, this topic also accommodates and provides guidance on the important differences between domestic and international contexts. So we hope that lawyers and judges alike will benefit from the guidance offered in this part of the new restatement, all of the parts that we discussed today. And we'd like to thank you again for listening. We thank you for any opportunity you have to read and comment on our draft, and we can't wait to see you in person soon. Please stay safe and healthy. Thank you.